Thanks everyone. Welcome to our lunch conversation on state preemption of local policymaking. My name is Mike Alfano. I'm the campaigning manager for the Campaign to Defend Local Solutions, and joining me on the panel here today to my right is Ann Morgan, who's the city attorney for the city of Austin, Texas. Next to her is council member Jillian Johnson from the city of Durham, North Carolina. Next to her is Mayor Paul Soglin from Madison, Wisconsin. And at the end, we have Jan Vernick, who is the professor of health policy and management at Johns Hopkins Bloomberg School of Public Health. And he is the co-director of the Johns Hopkins Center for Law and the Public's Health as well. We're going to talk today a little bit about what preemption is. I think it's a topic that some of you may be familiar with, but not everyone is. And then we're going to talk a little bit about the risks that preemption poses in chilling innovative policymaking at the local level. As we all know, the local level in cities is where policy experimentation and incubation takes place, and what preemption means for that. We're going to talk a little bit about some really aggressive and abusive forms of preemption and how it not only denies local control and local voices, but we're also going to talk about how it hurts cities' competitiveness and self-determination. We're also going to talk about how some of these aggressive and abusive forms of preemption specifically prevent cities from addressing some of the equity goals and equity challenges that we've heard about today. A lot of these great policy ideas have either been preempted or have come under threat in states all across the country. And then lastly, we're going to talk about what cities can do to help fight back against some of these combative, abusive forms of preemption, whether that's in the courts, arming ourselves with research, building coalitions, and other creative fixes. So just to start off, I'm going to turn to Jan. And Jan, will you kind of, as I said, I think some folks maybe in the room may be familiar with what preemption is, but can you talk a little bit about what preemption means and give a little bit of a historical context for it?
Sure, happy to. Thanks, Mike. So at the sort of most basic level, preemption means that law at a higher level of government prevents or preempts or invalidates law at a lower level of government. So that means that federal law can preempt either state or local law, and what we'll talk about mostly here is state law can then in turn preempt local law. And as Mike said, I've been a public health lawyer, researcher, practitioner for 25 years now, and frankly, I don't think I've yet encountered a public health area where preemption doesn't play a major role in what localities, what states are able to do. There's no area of public health that's untouched, whether it's injury or illness, whether it's infectious disease or chronic disease. It really is remarkable. So I'm so pleased that we're having this panel today. So I've been asked to give the sort of wonky background a little bit to what preemption is and set the stage. And although we're going to talk about mostly state preemption of local law, I'll note quickly, as I mentioned, that federal law can preempt either state or local law. The legal basis for federal preemption is something called the Supremacy Clause in the U.S. Constitution. That's the part of the U.S. Constitution that says federal law is the supreme law of the land, and there are a number of federal laws that preempt states and localities. Just one example is the Federal Cigarette Labeling and Advertising Act, which preempts both states and localities from doing lots of different things that they might want to do around cigarette advertising. I should point out, when we talk about law being preemptive, we mean either statutory law or regulatory law, acts of administrative agencies. At the state level, the legal basis for preemption is sort of more basic. It's that, in general, localities are seen by the law as creatures of the state, created by the state, and therefore the state can choose to give as much or as little home rule authority to the local governments as it wishes. It can provide very broad home rule authority, or it can provide more limited home rule authority, or it can choose to pick and choose. It can provide broad authority in some areas, but in others less authority. So in one of the areas that I work on, which is firearm violence prevention, beginning in the 1980s, more than 40 state legislatures have chosen to preempt most, or at least some kinds of local firearm laws. So as I'm sure we'll talk about, that has meant that localities are basically out of the business of enacting local gun policy kinds of laws. So the other thing you should know from the sort of legal wonky side of things is that there are two main flavors of preemption that we talk about. There's express preemption and there's implied preemption. Express preemption is pretty straightforward. It's when the preemption is stated very explicitly in the language of the federal or state statute. The federal or state statute very explicitly says we're not going to allow, let's talk in terms of localities, we're not going to allow localities to enact their own kinds of laws in this area. There actually can be sort of the opposite of express preemption written into statutes, something that we should talk about, where the legislature actually explicitly says there shall not be preemption. We don't mean to preempt localities. We want to preserve the ability of localities to act. And it's this kind of express preemption that industry groups, advocacy groups have been seeking for quite some time. I mentioned guns. In another area I work in, tobacco policy, there are a dozen states, for example, that expressly preempt local smoke-free laws in many kinds of areas. Implied preemption is a little bit trickier. It's not when there's express preemption, but when a court basically determines that even in the absence of express preemption, nevertheless, and again, let's talk about localities, nevertheless, localities are not allowed to act in a particular area. And there are two main flavors of implied preemption. There's one where a court says, well, even though there's not express preemption, the scope of the action that the state has taken suggests that the state intended to occupy the entire field of regulation. And then the other main flavor of implied preemption is when the court, again, these are court determinations, concludes that if local laws were permitted, they would conflict with state law or would otherwise frustrate the purposes of state law. And you can hear, just as I'm saying it, implied preemption can be this kind of uncertain area, and the practical upshot of it is that localities may not know whether preemption applies to them or not, and may even be affected just by the mere threat of preemption or the threat of litigation should they choose to act. And I'm sure that my other panelists will want to talk about this. So for me, the bottom line is that ultimately preemption isn't always bad. If the state or federal law is adequately protective, then maybe it's actually better to have a law that applies uniformly throughout the state or throughout the country. But so often that's not the case, and when we therefore have preemption, we stifle innovation at the local level. And for my money, what we ultimately need to make sure that doesn't happen are executives and legislatures willing to take risks, and I'm sure we'll talk about that, and also councils willing to say yes, which is always a harder thing for lawyers to figure out how to say the no, right? But happily, again, we have counsels on the stage here who are more practiced in saying yes. So thank you for giving me a chance, Mike, to give you the background, and I'm happy to jump in later as well.
Absolutely. Thank you, Jan. So we've heard a little bit about how preemption has historically worked and kind of how it can actually serve as a good role to ensure that there are certain protections in place. What we've seen in recent years, though, is a switch from preemption being used as a means to set standards across the board in a state that cities and counties can go above and beyond and build on if they want higher minimum wages or stronger protections for LGBTQ or non-discrimination ordinances. But what we've seen now is that preemption has moved from being a floor to acting as a ceiling and completely removing rulemaking authority for local governments in certain areas. We've also seen an increase in a new type of abusive form of preemption. One version is either, you may have heard of it, it's called super preemption or punitive preemption, where it actually allows local elected officials to be sued personally for votes that they make in their official capacity. It also potentially, some of the penalties attached to these laws. In Kentucky, a local elected official can potentially go to jail for voting to pass an ordinance that ultimately winds up being preempted. Another form of abusive preemption that we've seen arise has been termed blanket preemption, where a state comes in and says almost uniformly local governments can't regulate across a wide range of issue areas. And in Arizona, local governments can lose millions of dollars in state shared revenues if it's shown that they have passed a law that has been preempted and they refuse to remove that law from their books. But I want to turn now to Mayor Soglin and hear about how these new kind of uptick in preemption been carried out in Wisconsin, and how does preemption present challenges for your city's ability to be economically competitive?
Thank you. And to pick off, Mike, from your last comments, I think we ought to recognize that there are certain situations where we do want preemption either at the federal or the state level, and that much of this these days is now ideologically driven as the shift comes from a standard of good allowing local governments or states to do even better. Now it's to contain them and they have to do worse. And of course, if we go back to the 1960s in terms of the Supremacy Clause, we saw it in the Civil Rights Movement. And then when there were recalcitrant municipalities, we even had some states stepping in terms of voter rights, in terms of desegregation, doing the right thing. What I want to get to in the few minutes I've got here is to the recent RFP that was put out by Amazon. If you're not aware, Amazon has put out an RFP for a second headquarters here in the U.S. Where 230 municipalities have submitted proposals, even though it's estimated by Moody's that only 35 have a real practical chance. And I don't even want to get into a discussion about whether or not we love or hate Amazon in terms of what it's doing to our sense of place, but bear with me and I'll get there. I want to start back in 1972 and 73 in Madison when we negotiated a franchise agreement with a company which has now been succeeded by Charter Spectrum. We negotiated a franchise agreement for cable television in the municipality with no restrictions from the state. And in that agreement, we got commitments that they were going to roll out the entire city within a certain period of time. Every neighborhood, every home, every business would have access. We rolled out a system that was to provide public access, a public studio, as well as channels dedicated to providing information not just from the city government, the school district, and the county, but also for nonprofits and for individuals. I want to jump into the mid-1980s. At that time, the city of Madison had one of the highest standards for building codes in the state. And the legislature, led by progressives, preempted us and said, we want uniform building codes throughout the state. That is an interest of statewide concern. And while it may lower some of Madison's codes in terms of new construction, it will bring the rest of the state up to a better standard. at which point we said, why don't you do that but allow us to exceed them? And of course the response we got was no, because then it will not be uniform statewide. Jump into the 1990s, and then what we get is a city effort where we already locally regulated the sale of handguns. You could not buy a handgun in the city of Madison. We attempted to ban them with certain exceptions. Exceptions for sport, exceptions for retired law enforcement and military personnel and so on. Well, that then prompted the state legislature to step in and say, sorry, this is of statewide concern. All regulation of firearms is now our purview. You folks are done. Now I want to jump into this century. By 2006, 2007, what happens is when AT&T, and you'll excuse my language here, when AT&T buys our state legislature and preempts us in regards to not just cable TV, but in terms of internet connectivity, they basically ban us from doing any kind of agreement with the private sector in terms of developing rollout. Now, for those of you who have not followed this debate but use the internet, keep in mind that your municipality probably has a service that's 1/10 as fast as San Francisco. And keep in mind that San Francisco's is probably 1/100th the speed of Paris and Seoul, South Korea. So here in the United States, what's evolved is with AT&T's leadership and the complicity of Spectrum Charter, Comcast, and the others, we've got about half of the US states where there is legislation with incredible barriers for this kind of innovation in the world of both cable and internet connectivity, that we can no longer do what we did in the 1970s. And in fact, it's a major impediment to economic development. So now what I'd like to do is jump up to the Amazon situation. And it's not a complicated document. Their RFP is 5 pages long, and I want to just quote some of the segments out of it and then think about your own local situation, your own state. Amazon, in its RFP, notes that it wants a site that's similar to the attributes it has in the Seattle area, noting that its own work has been a catalyst for development in the Denny Triangle with its sustainable buildings. Well, in terms of sustainable buildings, many of our states have now been preempted in regards to regulation and setting standards for private development in regards to that key element to sustainability, because we can no longer whisper the words even climate change or global warming, because they don't exist. The site should be proximate, can't even read my handwriting here, proximate and create a sense of place and be pedestrian friendly. Then it goes on to say it should include connectivity options, including sidewalks and bike lanes. Well, in the very week that Amazon issued the RFP, our legislature changed the state laws in regards to condemnation, the ability to acquire right-of-way for transportation purposes. It used to be in Wisconsin, you could acquire a right-of-way for transportation purposes for any mode. It's no longer true. In Wisconsin, you can only now do condemnation, use the power of eminent domain for motor vehicles. You cannot do it for bicycle paths, and you cannot do it for sidewalks. Which means if Amazon were to choose a location in Wisconsin, we can't meet this critical transportation criteria that they require. And then lastly, we have to demonstrate fiber connectivity for all suitable sites. And of course, with the preemption in this particular area by the existing industry, which is more interested in churning customers than it is in giving us upload and download speeds. And by the way, let me just make this note for you. Don't be solely focused on download speeds. This is not just about the gamer in your household. If you want economic development, businesses have to have upload. They have to have the ability to send large quantities of data to other sources. So with that, where we've got a series of actions, principally led by the right wing in an effort to make us reimagine America in the image of the Koch brothers, which is a system of government that does only one thing, which is to protect business. They are in effect, by these type of actions, depriving us of the robust mobility that we need, the innovation, to address modern 21st century companies. And just like to thank you for having this opportunity to share. I could go into a lot of other areas involving landlord-tenant relations, which has now been preempted in Wisconsin, minimum wage, all sorts of worker protections. And in fact, let me just conclude by noting that one of the things that we did is we established a $15 minimum wage for city employees. While we can't regulate it for the municipality now because of preemption, we can at least raise the bar in terms of city government. And as we go into our second year of this 3-year rollout, we also have agreements with labor associations, since union negotiations are now banned in Wisconsin except for police and fire. Well, there's a new bill in the legislature right now to preempt all of this other work. So every time we figure out a creative way of working around their tragedies, they are relentless. They have tremendous imaginations to take us back to the dark ages, and they're not done yet.
That's so frustrating, and you know, you mentioned, you know, every time you want to address an issue that the state comes in and preempts you. I've had the privilege of working with Councilmember Johnson before, and it sounds very similar to North Carolina, where it seems like they've gone after everything under the sun. Councilmember, can you talk a little bit about the situation in North Carolina, especially as, you know, we've heard, as I mentioned, some great policy approaches to addressing racial and economic equity in cities. Can you talk about a little bit about your efforts to address those challenges and how preemption has made that even harder?
Yeah, thanks, Mike. So North Carolina is this working? I can't tell. No. Okay, we good? Great. So North Carolina is often described as ground zero for preemption, which is a characterization which I have found very accurate in my few years of being a council member. We have had everything under the sun preempted, from wage ordinances to non-discrimination to even something as mundane as the ability for municipalities to charge inspection fees to utility contractors. I'm going to focus on, like Mayor Coughlin, I could go on all day, so I'm going to try to focus on a few specific examples that we've dealt with in Durham over the last few years. Like Wisconsin, we are already preempted from having a municipal living wage ordinance, but we weren't in North Carolina preempted from requiring our city contractors to pay living wages. So in Durham, we had a living wage ordinance beginning in the 1990s, and we passed an ordinance that required city contractors to also pay the city living wage to their employees. A few years later, the state passed large bill which preempted us from regulating in any way the wage and benefits requirements for municipal contractors. Because we had so many contractors, this affected a huge portion of our workforce, and those folks actually saw their wages and their benefits reduced. As a result of this legislation, we had to take our requirement off the books. And because we are required by law to choose the lowest responsive bidder for contracts, we have now no way of ensuring that any contractors doing city work are treating their workers fairly. We also very recently, and I'm sure most folks in the room heard about HB2, which was North Carolina's bathroom bill, trans-exclusive bathroom bill, which passed our legislature and resulted in a very intense boycott from municipalities all over the country. HB2 was a preemption bill. The city of Charlotte had passed a comprehensive non-discrimination ordinance that included protections for gender identity, gender expression, and sexual orientation. The North Carolina General Assembly decided to preempt that bill with HB2, which went even farther than the Charlotte bill in the opposite direction by banning all North Carolina municipalities from having non-discrimination ordinances that included those protections. And so HB2 was eventually repealed after a huge amount of pressure, primarily from the NCAA, because North Carolina loves their basketball. When the NCAA started threatening to move games from North Carolina, eventually a compromise was made. Unfortunately, that compromise also preempts municipalities from having non-discrimination ordinances that include gender identity, sexual orientation, and gender expression. It does not explicitly ban transgender North Carolinians from using the restroom that they choose, but it does still prevent municipalities from proactively protecting our residents in those choices. So we had a terrible preemption bill, and we're left with a terrible preemption. And we have also very recently, just in my tenure on the city council, come up against a very explicit, corporate motivated preemption of our ability to charge inspection fees for utilities. So we in Durham realized that we were losing money on utility inspections, that we were only recovering something like 20 to 25% of the cost that the city was actually expending to inspect new installations of fiber, primarily fiber optic cables that are going in, and we are supposed to be getting, AT&T is installing a fiber network, Time Warner Cable, and also Google. And so we realized as all these fiber networks were going in that this was going to be a major loss of revenue for us, with all of these companies coming in to install fiber, that our inspection fee structure needed to change. The utilities got wind of this. They hired several lawyers and came to the council to argue with us that we should continue to subsidize 80% of the cost of inspecting their fiber installations. We eventually negotiated on our council and I won't want to say in consultation with the lawyers, because we shouldn't really be arguing with utility, with corporate lawyers about what we're doing in our city, but we did have a number of conversations with them, came to an agreement that we would try to set our fees to recover 50% of the cost. But at the same time, these folks were discussing this issue with members of the General Assembly, and they came back with a bill that essentially bans us from setting fees at anything higher than the actual cost of a person going out and doing the inspection. In order to set those fees, we would have to analyze the exact cost within our department of every single utility installation and then set those fees manually. So the cost to the city of actually going through that process would be astronomical. And this bill was, we know, as a direct result of Durham looking into increasing our fees in order to stop subsidizing major utility companies in providing this service. And I say I could go on all day, but the final thing I want to talk about is also a similar situation where we were in the process of creating legislation that we felt would be a benefit to our residents and were preempted by the state So we recently implemented body cameras in the city of Durham for police officers, and we were working on developing the policies under which those body cameras would be rolled out. And so I believe that body cameras can either be a tool for transparency or they can be a tool for mass state surveillance, and the key difference is the policies under which they are rolled out. And so we were working on developing a very transparent and accessible body camera policy where residents would have access to that footage within reasonable guidelines to also protect the privacy of the folks who were pictured in the footage, but that residents would have some form of access, and that would be, in order for those cameras to be used as a tool for accountability, we felt that level of transparency was necessary. As a direct result of municipalities considering body cameras and looking into these more transparent procedures, and also a police shooting in Charlotte where police body camera video was released to the public, the General Assembly rolled out a bill which requires municipalities, or requires anyone who wants to see body camera footage to obtain a court order unless that footage is ordered by the police chief of the municipality. So the only person now in the city of Durham who can release body camera footage is our police chief, and the only way to get it otherwise, or to reverse that person's decision, is by going to court, arguing your case and getting a court order, which is of course an insurmountable barrier for I would say the majority of people who are interacting with the police department in our city. So those are just a few examples of what life looks like in North Carolina right now. And I think later on we're going to talk a little bit about some of the strategies that we are exploring to try to challenge some of those roles.
Yeah, that's right. This isn't all just doom and gloom, I promise.
That did feel really doomy and gloomy.
So we've talked a little bit about the rise in preemption and how it's being used to target individual cities, particularly when they try to address some of these issues that we've been talking about here today. I want to shift and talk a little bit, and to go to City Attorney Morgan, and talk a little bit about super preemption. These are these incredibly punitive preemption laws that, one of which, SB 4 in Texas, which you all may have heard about, got a lot of national attention. Can you talk a little bit about how preemption has changed in Texas, and then talk a little bit about your legal strategies in addressing it?
Should be happy to. Thank you. I will say that preemption is something that we always talk about as a lawyer. We describe it to our council members when they come into office as this is how we operate. You are a home rule city. The people of the state, through the Texas Constitution and through our charter for the city of Austin, have given you the power to govern locally. And you can do anything that is not prohibited by the state of Texas. I worked for the city for 13 years. I came as the chief of litigation. I've been the deputy city attorney, now the city attorney. And we have rocked along with that for many years very comfortably, and we're cautious, we're the lawyers, and we tell them what they absolutely cannot do, what they absolutely can do, and they always play in the gray area. And our council has passed a lot of things that are forward thinking. We protect the LGBTQ community in our fair housing ordinance long before anybody talked about it much. We have a fair payday lending that we've gotten passed that nobody's bothered us about, really. We have all kinds of things that we have done. Well, life has really changed recently. The Sanctuary City Bill is what I'm going to talk about for the bulk of this. And let me just tell you that in Texas, the legislature meets every other year. So in odd years, they come in January, they work, and they go home in May. In January of 2017, Governor Abbott came in and he said there are 4 emergency things that we need to pass. One is to take care of the Child Protective Services Department, which needed some help, and that was an emergency. He said we need to do ethics reform. That didn't pass. He said we need to take care of support a U.S. Constitution change to rein in federal power. That didn't pass. And the 4th one was to punish cities that provide sanctuary to undocumented immigrants. There were 3 different bills introduced about sanctuary cities, and that was a big debate throughout the session. And there were lots of things that people tried to pass to put into the bill. And I'm just going to read language because it's really important, I think, to say exactly what the bill does. The SB 4 bill that did pass is titled Enforcement of State and Federal Immigration by Local Entities and Campus Police Departments. So this affects the universities in our state. It prohibits entities such as the city from adopting, enforcing, or endorsing any policy which can be an informal and unwritten policy that prohibits or materially limits local officers from enforcing immigration laws. 2, it prohibits us from demonstrating a pattern and practice of materially limiting immigration enforcement. It prohibits us from limiting officers and a bunch of other people from inquiring into immigration status, sharing information on immigration status with ICE, the Immigration and Customs Enforcement Agency, maintaining that information, or assisting ICE, allowing ICE into the jail. We're not involved in the city of Boston. The cities are not involved in immigration policy. What our police officers do is we try and have them do community policing. We don't maintain this kind of information because it's not part of the role that we play. But this bill is to specifically prohibit us from doing all of these things. The final version of the bill allows police officers to ask these questions during any kind of a detainment, like a traffic stop. You don't have to be arrested to be able to ask these questions. The bill also provides civil and criminal penalties, and I think this is what Mike was referring to earlier. So there are 3 different categories. The Attorney General in Texas may file suit against the city for violating this, and the penalty is between $1,000 and $1,500 for the first offense, and $25,000 for each subsequent infraction, and every day is an infraction. SB 4 provides that it is this is about people now, it's a Class A misdemeanor if local officials don't cooperate with ICE agents. That's really our police chief. Then elected or appointed officials who violate the law may be removed from office. So those are individuals. So it was quite a big deal. And when the lawyers in my office, we of course during the legislative session track all the bills that come through, and people started coming and telling us about SB 4 and the other pieces of legislation that dealt with sanctuary cities. And I said, just don't be ridiculous. This is never going to pass. You've got to be kidding me. I was wrong. One of the things, 2 things that were originally in the bill that didn't pass, but this is just what was out there in a conversation. One section threatened all state funding for non-compliance, and that would be funding that had nothing to do with immigration, but just anything generally. And also there was a section that made cities liable for damages if a person who was subject to an ICE detainer had been released by a local entity and then committed a felony for the next 10 years. Would have made the city liable for that. So anybody can think of the San Francisco, terrible tragedy that happened. There was, as you can imagine, a great deal of protest about this sanctuary city bills as they went through. Our police chief, both our current police chief and our former police chief, who now is in Houston, both testified against the bill. What they said is, we want to help people who are immigrants in our community come and work with us. We don't want to scare people. Our council members were very much against the bill. People protested at the Capitol. 1,600 people testified against the bill and 8 testified for it. Despite all that, of course, it did pass. This was kind of funny to me. The bill passed in May. The beginning part of May, the governor who signed the bill, he signed it on Facebook on a Sunday evening in about a 5-minute ceremony, which was not announced to anybody beforehand. So, of course, we didn't have the protests that had been ongoing during the session. And the same night, on a Sunday evening, the Attorney General in Texas filed a lawsuit in federal court in Austin against us. On a Sunday, you can file a bill at any time. File a lawsuit electronically. So he filed it on Sunday evening. Monday, I started getting rumors about this. You're going to be getting sued. Well, we'd already been sued. The lawsuit was against 16 entities, individual parties. He sued Travis County and Travis County Sheriff. They actually run the jail in Travis County, is the county surrounding Austin. He sued the city of Austin, each of our 11 individual council members, and our city manager, who's the administrator of the city. And he sued MALDEF, which is a nonprofit organization in Texas, very powerful, very important in Texas, called the Mexican American Legal Defense and Education Fund. And the lawsuit asks the federal judge in Austin to declare that SB 4 is constitutional. It's an interesting twist. His reason for bringing the suit and naming the defendants he did, including the nonprofit organization, was that we were, and this is a direct quote, publicly hostile to cooperation with the federal immigration enforcement, and that the named parties were going to sue Texas over the constitutionality of SB 4. So anticipatory suing. Well, I must say that we were contemplating suing. So there was some truth in that. So then the litigation begins, and I think this is really what we were trying to think where we get to on this preemption bill. We filed our lawsuit in San Antonio, Texas, in federal court. The first lawsuit was filed by the tiny border town of El Cenizo by a lawyer there who's very courageous. And the next days and weeks, many of the cities in Austin, the blue dots in the red states sued, counties sued, individuals got involved. And our arguments essentially were that SB 4, immigration law, is preempted by federal law, and that it will interfere with the federal government's authority to control immigration and our local police power. So that's, we use preemption the other way. We said it violates the First Amendment because it says I can't say anything about it. It is constitutionally vague, violates due process, because what in the world do those words mean? And then the mandatory detainer provision will create Fourth Amendment violations, illegal search and seizure, because when you're stopping somebody and asking them about race, what's it based on? You're going to ask me? For the city of Austin, we also argued that SB 4 violated our home rule provision of the Texas Constitution, and we argued that the state was interfering again with our police power. Now, I will say that the home rule argument has not gained the most traction because there was so much other stuff in the bill that everybody's been excited about. But I think it's a really important issue that we need to talk about is the home rule aspect of this. The court proceedings, the case is still in litigation, and I anticipate that the case will go to the U.S. Supreme Court, but in the short version is there was a hearing in San Antonio in that federal court, Judge Orlando Garcia's court. He waited till the very last day before it would have gone into effect, and he issued a temporary injunction in the case, allowing one tiny part of it to go into effect, but essentially staying the rest of it. The state of Texas immediately filed an emergency appeal to the Fifth Circuit Court of Appeals in New Orleans. Not our friend necessarily. That court granted the emergency injunction, held a hearing on a Friday, and the next Monday issued its ruling. It's a little hasty. And that ruling is a bit confusing, but it emboldened the Texas Attorney General when he got the ruling that he issued a press release and said, essentially, we've won, I welcome your complaints. Because anybody who's in Austin can file a complaint against all those people I listed before, and the Texas Attorney General can investigate and go forward. So that's where we stand right now. And so we haven't gotten a complaint yet. Certainly could be anticipating one. And again, the fee involved, it's $1,000 to $1,500 per day. The next violation is $25,000, and that's for the city itself. The criminal prosecution is against somebody like our police chief, and the removal from office is for somebody who is elected or appointed to the city. So I think that, and we may talk about it a little bit more, I think that what's happened in the litigation arena is we for years went along and said, if we're preempted, let's try and craft our legislation in a way that is going to be sound, that won't be preempted. I think this animosity that has occurred between the state government and some of our cities is really, it's making the state want to sue us more. And we have 4 lawsuits that the state either filed against our city as an entity, filed against us or intervened in things like this, short-term rentals, the ordinance we have, handguns in our city hall, a couple of other things. And it has also emboldened our council members. So we have a courageous bunch of people who are our elected officials, and I think they think maybe this is the time to fight back. And one we've done is on our source of income ordinance, which probably many of you cities have, where we passed an ordinance that said you can't discriminate against somebody because they have source of income, like a housing voucher. And went into place, we're proud of it. State legislature came along and preempted, 2 years ago, and preempted us on that. And we went, well, that's the way it is. After this, we went, you know what, we're just gonna have to sue over it. So we filed a lawsuit over that, and so that's pending as well.
Great, yeah. So collaborative legal challenges is clearly one tactic that folks can use when these over-the-line preemption bills get put in place. To very briefly, shamelessly plug my own work with the Campaign to Defend Local Solutions, we've been really focusing on public education and awareness building around this issue. So many times the average person has no idea what preemption is, or how, when they hear the word preemption or local control or home rule, that's not something that resonates with them. So we've been working to host public education events. We've run a very aggressive media campaign that's resulted in 70 different articles being published about our efforts to get the message to the local folks, local voters, that this impacts you on your everyday life, whether it's for higher minimum wages, whether it's for paid health benefits, whether it's for anti-discrimination ordinances, whether it's environmental regulations, whether it's public safety. It touches almost every area of law that you can imagine, and it's so much easier for you at the local level to hold your local official, as I'm sure so many folks in this room can attest to, accountable, whether it's on date night or in the grocery store or at a local council meeting. So we've really been working to build public awareness around this issue. Jan, what role is there for researchers to play in kind of pushing back on preemption?
Well, I think there's actually a handful of different roles that researchers can play. Researchers can help the work that you're doing by demonstrating through empirical research how important and beneficial local law can be. Researchers can do public opinion research to try to demonstrate to the state legislature, for example, that local residents want local control, that they want the flexibility to address local problems locally. And then finally, there's the kind of legal research that Anne is talking about. There have been places where it was thought that preemption was broader than it actually was. In California, for example, for many years, localities were unwilling to do anything about certain kinds of handguns that were sold because everyone was told that there was preemption. Well, some innovative legal research was conducted to demonstrate that actually this was one of the areas where you could regulate sort of in the gaps of preemption, and as a result 30 cities enacted new kinds of laws, and that proved to be the engine and laboratory of innovation for state policy as well. So I think there's a lot of different places where different forms of research can be helpful.
Absolutely, and I guess I'm going to open up a little bit more. What other creative workarounds have you all who are leading the policy setting side of your local governments? What other creative workarounds and solutions have you found to be able to kind of operate within preemption's lens?
I can tell you it's been difficult. The one thing that I has been excited about lately, our staff figured out, was a workaround for the utility inspection fees, which is basically that we're not going to do them anymore. We're going to outsource them, and the utilities will be required to pay for their own inspection directly to a third-party contractor. This, of course, gets around the fact that we can't charge them, and so we're not losing money. There is but what I was concerned about was then how do we make sure that those third-party contractors are actually doing the inspections well enough so that they do meet our standards and we're not getting calls from residents about AT&T dug up my yard, they didn't fix it. So we are going to have to implement behind that some sort of checking procedure where we check every inspector. But it is going to be it is going to be a money-saving method. It will save us money and it will save us some time and effort. What is really frustrating, though, is the amount of energy and creative thinking and figuring that our staff has to do to get around something like this, and for what, so that a utility company can make a little bit more money. When we could be putting all of that innovative thinking and creativity and drive towards coming up with exciting solutions to actually solve our city's problems. Instead, we're trying to figure out how to get around these regulations from our General Assembly. But I agree that this new wave of preemption has emboldened policymakers, and I was thinking about something that Councilman Brandon Scott said on the previous panel, is that we need elected officials who aren't afraid to be unelected for doing the right thing. And I think in North Carolina especially, we need cities who are willing to fight back against state preemption, and we need to be doing that together. So we're trying to form partnerships with elected officials in other municipalities and counties in North Carolina to figure out how we can work together to push back on some of these issues that are having a negative effect on all of our communities. And it's much easier for the state to mount an attack on one city. It was very easy for them to just preempt Charlotte's non-discrimination ordinance, but it would be very difficult if all of the major cities in North Carolina were to pass something at the same time and then maybe preemptively sue the state for our right to do so. And so I think there's a legal strategy, there's work, collaboration that needs to happen, and then we're still going to have to be coming up, with workarounds wherever we can. But I think thinking long term, we really need to be figuring out how we can prevent this sort of action before it starts, by making it more costly for the state to impose these sort of regulations.
Mayor Soglin, I see you want to respond as well, and let's go ahead and do that. But if we could transition then into, since we're about out of time, if everybody just gives as well just one last kind of word of advice, optimism, whatever it may be. So if you can lead us off on that as well.
As I mentioned earlier, when we became a right-to-work state and they basically dismantled the public employees' unions, we sat down with a workers' association, and keep in mind, we're talking the traditional hours, wages, and working conditions. And so what we did is we codified those processes and then adopted them as a city ordinance. Now, in terms of sanctuary cities, let me just go to a larger issue here, which is how do we frame it, and how do we, especially if we're blue cities and red states, how do we take the message to a larger audience? Because so much of what the preemption does, besides being hypocritical, is it goes at the very foundation of smaller communities and their belief in local control. And I wish the phrase sanctuary city had never been created. You think of sanctuary, you think of Charles Lawton furiously ringing the church bells, screaming sanctuary, sanctuary, and that's not what this is about. What it's about is, does the federal government have the ability to go beyond federal law and control local police departments? If you talk about the federalizing of local police departments, that gets scary to everybody. And so how we frame that discussion becomes really critical. And I think not only do we have legislative workarounds, but we have a discussion we have to take out there to a broader community.
Jan, you want to start and then go down the
last words. Okay, well, so very, very quickly, my last word to you all is don't accept preemption. It's too important. It's too important for you to simply accept it. And therefore, you need to work with the courageous mayor, the courageous city attorney, the courageous legislatures, and you need to work with groups like the 21st Century Cities Initiative. You need to come together to learn from each other, because it's much, much easier to fight this as a group.
Me? Yeah, I've been thinking a lot about pipelines to other roles in city government. So we now, since Trump has been elected, right, lots of people are thinking about pipelines to elected office. And I think there's 4 or 5 new projects that I've learned about just in the last year to try to recruit folks to run for public office. I think we also need pipelines for positions like city attorneys and city managers and those staff people who really are working every day to figure out how to handle preemption. I think we need every city attorney to be a civil rights attorney, to really think about their job not just as protecting the city from lawsuits, but proactively defending the rights of our residents in court. And I think having those sorts of people in those positions will put us all in a much better position to fight things like state preemption and fight for our residents in other areas as well.
That's interesting. I would say that being optimistic, this kind of a gathering, this is like the 3rd time I've had this kind of a conversation, and it's made a big difference. It makes a big difference to be able to think about these in a way that's a little bit fresh and more proactive. And so I think this is really, really helpful, and I appreciate 21st century is putting it on.
Yeah, I think we all echo that sentiment. So I think that's us. Thank you all so much for your attention. Really appreciate it. And thank you.